really one of my favorite topics. I kind of geek out about contracts, which is weird. My wife always makes fun of me about it, but when you really understand what contracts are and what they do and the purpose that they serve in terms of being able to help people form relationships within society, and in this context, particularly when it comes to business, it's so interesting, just the things that you can do with contracts. The potentials are almost endless and limitless, as long as everything stays legal. And so today's workshop is really about helping you to gain a basic understanding of contracts and understanding what makes a good contract, right? What goes into a good contract, what qualities does a good contract have, and how can you spot one, and what do you need to make sure is in that contract to make sure that you're protected and that everything is laid out in a way that's going to lead to success for your business. And so I'm going to jump into everything really quick. I'll give a quick introduction to myself. My name is Zane Johnson. I'm the founder and managing attorney of MZA Legal. We are a virtual law firm, a Black-owned virtual law firm that serves Philadelphia and the surrounding counties, focusing primarily on empowering the next generation of entrepreneurs. So helping new business owners, new entrepreneurs to set a solid foundation for their business, take advantage of new opportunities, and protect themselves from catastrophic mistakes. And so I'm glad that you were able to join me this morning. Feel free to chime in. I mean, I feel like this is going to be, if no one else joins, this is, a great opportunity for you to just, kind of ask whatever questions you have, and just, free range to get those questions answered. But, as we go through the presentation, like I said, just feel free to jump in wherever you have a question, comment, etc. So without any further ado, we'll jump right into it with kind of the most basic question here, and that's, what is a contract, right? And so a contract is really just a written or spoken agreement that's intended to be enforceable by law. All right. And so the distinction that I want to make is that a contract is always an agreement. Now, all contracts are agreements, but not all agreements are contracts, right? And so one of the funny things with the law is that there are terms that we use every day that, when they're used in a legal context, have a very specific legal meaning in terms of what is, in this case, a contract. All right. And so the difference between a contract and an agreement is, you and I can make an agreement. You might say, all right, I'm going to give you a gift for Christmas, and it's going to be a new bicycle. And that's great. And I heard you say that, and I understood that, you're going to give me that bicycle for Christmas. And so I'm looking forward to it. And then you don't give me the bicycle for Christmas. You don't give me that gift. And so we had an agreement, but it's not a contract, because it doesn't meet the specific legal requirements for us to have a contract. And so that's where the difference comes in. Again, all contracts are agreements, but not all agreements are contracts, right? And the difference really lies in whether or not the agreement is legally enforceable. All right. And so what then makes a contract legally enforceable? How do we make a contract that's legally enforceable, right? And so, in other words, what conditions have to be present in order for a contract, or in order for an agreement to become a contract and become legally enforceable? And there are basically 6 different requirements. Depending on what you're looking at or who you ask, these can kind of differ because they're all kind of related in some different ways. But the basic elements of a contract are offer, consideration, acceptance, mutual assent, legality, and capacity. All right, so those are the 6 basic conditions for a contract to exist, a legally enforceable contract. And so an offer, again, like I said, in legal context, we use a lot of words that we might use every day, that in a legal context have a very specific meaning and definition. All right. And offer is one of those things. So an offer is when one party offers a deal to another, right? So I will do X in exchange for Y. And there might be multiple offers back and forth, throughout a negotiation process, and counter offers. But before the parties actually reach an agreement, it starts with an offer. Before they actually create a contract, it starts with an offer. I'll do X in exchange for Y. The exchange part is what's called consideration. All right. And so consideration means that both parties are promising to do something or not do something. Basically, both parties are making different obligations or placing different obligations on themselves based on the terms of the contract. All right. And so, in the example that I gave just a second ago on the last slide, there isn't consideration there because you're saying, I'll give you a bicycle, but I'm not promising you anything in return, right? And so because there's no consideration, that doesn't create a legally enforceable contract. It's really just a promise, even though the two of us had an understanding about what you said you were going to do and everybody was on board with that. There's no consideration because I'm not making an obligation or holding myself to an obligation in return for your obligation. All right. The next requirement is acceptance, right? So you have an offer and then you have to have acceptance of that offer. So whether you have multiple offers or counter offers, at some point in order to create a contract, one of those parties has to accept the offer that was given by the other party. All right. The next requirement is mutual assent, which means that the parties have agreed to the same terms, the same essential terms in the agreement, right? And so sometimes there are situations where folks during the negotiation process or as they're kind of figuring out what the contract is gonna say, specifically when we talk about verbal contracts and verbal negotiations, there are situations where two parties might be going back and forth, and they might actually have a different understanding of what they've actually agreed to, right? And so, we might be, I might be a manufacturer, and you might be, someone who provides materials for manufacturing, and I might say, I need this specific model of or I'm trying to think this particular piece of equipment, right? And you provide that equipment, but we have a different understanding of maybe what that equipment is, right? Maybe I say that the equipment is made by this particular brand and it's this model, but you misunderstand what model I'm asking for, right? And so when it comes to those essential terms, right, and I'll talk a little bit more about what those essential terms are, but when it comes to the essential terms of a contract, both parties have to be on the same page. And if they're not on the same page about what they're agreeing to, essentially, then no contract has been created. All right. And then last but not least, legality and capacity are basically legal requirements. Number one, that say in terms of legality, a contract has to involve a legal obligations, right? So we can't have a binding contract where, it's like I'm asking you, I say, hey, you go break into this store and steal everything that's in there and I'll give you 10%. That's not a legally binding contract, right? You can't go into court and get that enforced because what we're agreeing to is illegal. All right. And then capacity similarly is saying that a contract is not valid unless both parties have actual capacity to enter into a contract. And so folks who don't have capacity would be children, people who are mentally incapacitated. For example, if they've been ruled by a court to not have the mental capacity to enter into an agreement, those are situations where one of the parties does not have the mental capacity to enter into an actual agreement. All right. And so now that we know how to make a contract, I want to touch on why contracts are so important. Because again, like I said, I get really excited about contracts. I know that most people don't, but I love writing contracts. I love reading contracts. I love talking about contracts, if you can't tell. And one of the things what really makes contracts exciting to me is that when you think about what a contract is and what people are doing when they create a contract, they're really creating private law, right? They're really creating laws or rules that are legally enforceable that will apply to their relationship. And I think that this is so, to think about contracts in this way is very insightful. It gives you a different perspective because what you're really doing is you're able to create the boundaries for that business relationship and say, here are the standards that we're going to hold each other to, or here are the obligations that we're going to hold each other to. And people really get to decide for themselves, how they want to structure their relationships in a business context, right? And so, like I said, in contracts really give people the opportunity to choose the rules that will apply to their relationship, and then have confidence that those rules, that they'll actually be able to have those rules be enforced by taking someone to court if need be. But really, contracts, and in terms of the way that I think about them, a good contract is designed to keep you out of court. And so, as useful as contracts can be to be able to prove whether or not someone carried out their responsibilities and obligations under an agreement, really the real purpose of a contract should be to keep you out of court. It should be to provide the structure for that business relationship, to where if there's an issue, if there's a dispute, if there's a misunderstanding, hopefully it's something that you've already thought of and covered in your agreement, and you can go back to and say, okay, this is how we will handle this situation in a way that's going to ultimately keep us out of court, help us save money, and really build a trusting relationship. And so that's why I always say that contracts are the backbone of successful business relationships, because they outline that relationship and what it's going to look like, and allow the parties to have a greater level of trust that the other side is actually going to carry through on that, because there's the full force of the law backing those obligations and requirements under the contract. So now that we know what a contract is, and we know why contracts are important, I want to spend the rest of the presentation really talking about what goes into a good contract, or what makes a good contract, right? And a lot of this is subjective, but really just basing this off of my experience and working with folks and reading contracts and drafting contracts and seeing contracts go bad and seeing things go well. I think that there are certain things that go into a contract that make it good. Again, with the understanding that the purpose of the contract really is to create a successful business relationship, is to help build trust, is to help two people or two organizations be able to come together and pursue a mutual goal. And it's also to help keep you out of court. Again, like, these are the goals that we're thinking about. And so with those goals in mind, number one, a contract should be clearly written in plain English. And I think a lot of times folks think about contracts as these super formal, agreements and documents that have to have Latin in them and have to start off with like 10 wherefores and, have to be notarized and have all these, really, kind of complex things in them that only lawyers can understand. And I think that is a problem that we have in terms of people understanding what contracts are and what they're really for. And so contracts really need to be demystified. A contract should be clearly written in plain English so that both of the parties can understand them. Now, of course, it's really important that a contract be written in a way that makes sure that a court understands how to interpret them, and that it's going to be predictable. There will be predictable outcomes, hopefully, if both parties end up in court. However, the mistake that a lot of people make is they try to draft a contract for a court or for a judge to read exclusively, and exclude the idea that a contract should also be written for the parties to be able to read, for the parties to be able to refer to, and for the parties to be able to look at and understand what their obligations are under the contract, so they can just come to an agreement on something if it's a dispute or if it's a misunderstanding, and say, this is how we're going to move forward with it. And so a contract should be clearly written. It doesn't have to have, again, a whole bunch of legalese, a whole bunch of unclear terms. It doesn't have to be this complicated document. It can be something very simple, as long as it properly outlines the agreement and arrangement between the people who are entering into the contract. Next, a contract should be unambiguous, and this kind of dovetails or goes nicely with the first one in terms of a contract being clearly written. But unambiguous is important for me to kind of say this as a separate quality that a good contract should have, because ambiguity is something that is often included in contracts and to a large extent is unavoidable, right? Like there are some things within a contract that you're going to try to lay out, or you're going to try to anticipate what's going to happen, and you can't anticipate everything. But when I talk about a contract being unambiguous, it means that when I put something in the contract, it should be very clear what that means. There shouldn't be any sort of confusion about, when I put a term in a contract, there shouldn't be any confusion around what that term means and what obligations people have based on that term. And so to give you an example, I was actually reading a contract the other day that someone had sent over to me, and in the contract, it said that a certain obligation was supposed to last for a 3-year period ending on a specific date, and that specific date was the date of termination of the contract. That was pretty ambiguous because it gave the end date for the contract, but it gave the end date for that term in terms of, the end date for this 3-year term will be the date when the contract is terminated. But it didn't say anything about, necessarily, does that start date mean that the start date for that obligation begins 3 years before the date of termination? Because then it's backdating that term to a time potentially when that contract wasn't in existence, right? And so that creates different issues and different problems, and it didn't address any of those things, right? And so when I talk about a contract being unambiguous, that's what I mean, is that a contract should be very clear about what it's expressing and what obligations all of the parties have in relation to the terms in the agreement. A contract should also be complete. All right. And when I say complete, I mean that it needs to address all of the issues, all of the primary issues and likely issues that might pop up in the future. Right. And so it should cover, and I'm going to go through later on, kind of all the main points that a good contract covers, but a contract has to be very complete in terms of just making sure that it covers all of the obligations that each of the parties have, and their understanding of what their agreement is, right? So it shouldn't leave anything out, shouldn't leave anything open for question. If you talked about something with someone and you came to an agreement with them about that, it needs to be in the contract, or it needs to be written in ink to make sure that if something happens, everybody is able to refer back to that document and remain on the same page. And lastly, last but not least, a good contract should be fair. And when I say fair, I don't mean equal. All right. And so I want to be clear about that, because I think a lot of people think about contracts in terms of, or scratch that, let me say it this way. A lot of times the ways in which we approach contracts, or situations where we see contracts or interact with them, are situations where we're dealing with a large company or a large corporation as a consumer. And so we don't have any sort of ability to kind of negotiate that. It's kind of either a take it or leave it situation. And a lot of times we tend to think of that as like, that is what's normal, or that's just how things should be when it comes to a contract. But honestly, contracts should be fair. And again, this goes back to the idea or the purpose of a contract really being set on creating a relationship that's going to be successful. And so in business, particularly as a small business, if you're working with other businesses and you're creating a relationship with them, having a contract that is unfair to either party is setting both of you up for failure, right? Because the other party if it's the other party that the contract is unfair to, they're going to resent that. And if the contract is unfair to you, you're going to harbor resentment, right? And so you're already setting your business relationship up for failure because you're always already in a position where one party has resentment against another. And so how are you supposed to ultimately work together to obtain, mutually beneficial goals if you're already feeling like you're working against one another, right? And so again, a contract doesn't have to be equal. It doesn't mean that the both parties get the same thing, but it should be fair, right? It should put both parties in a position where they're both able to have some sort of benefit or recognize some sort of benefit from the agreement, and where it doesn't place a whole lot of extra burden on one party versus the other party, right? And so it should be fair, and when contracts are fair, again, it puts both parties in a position where they're more likely to be successful long term in their business relationship. So we talked about, that covers the qualities of a good contract, what makes up a good contract. But now I want to shift gears a little bit and talk about what terms need to be included in contracts, right? Like what things, I talked about completeness being one of those qualities, key qualities of a good contract. And so what are the terms that need to be in a contract in order for it to be complete? So generally speaking, a contract, obviously should describe and name the people who are parties to the contract. And just in case it's not clear, the parties to the contract are the people who sign the contract and enter into the agreement, right? And so a contract needs to obviously describe and name the people who are entering into that contract. Otherwise, it's not going to be clear who those people are and who owes what obligation. And this probably sounds like, pretty obvious, but sometimes it's not as obvious, right? Like, so there can be situations where, and a really just common example, right, is if I'm doing business, let's say I run my own business and I'm a solo entrepreneur, and I typically work with other businesses providing them services as an independent contractor, right? When I sign that contract, I need to be aware of the fact on whether or not I should be signing that contract as an individual, as myself, as Zane Johnson, or do I need to be signing that contract as my company or as my corporation, right? And so there's a difference between the two, even though it's the same person signing the agreement. If the contract incorrectly identifies me as Zane Johnson, where it should be identifying, the company as entering into that agreement, that can have very significant legal consequences. For example, in that example, if I sign that agreement as Zane Johnson, now I'm personally liable for the terms of that agreement, and I can be personally sued for things that happen in relation to that agreement. Versus if I sign it as Zane Johnson as the sole member of Zane Johnson LLC. Now the LLC is signing that contract, and I'm not personally liable or personally responsible for the obligations within that contract. And so, again, something that probably seems obvious, but sometimes can get a little tricky. And so it's important to understand and be aware of who is entering into this agreement and make it very clear who has obligations and requirements under this agreement. Next, we have the contract duration or the term, and that's the term is the term that we typically use when we talk about how long a contract will last. So, what is the term of the contract? How long will it last? And that's something that absolutely needs to be covered in the agreement, right? You need to make it very clear in terms of, is this a month-to-month agreement? Is this a yearly agreement? Is this agreement going to last for 6 months? Is this an agreement that's going to last for 5 years, 10 years? Depending on what industry you're in or what type of contract it is, different lengths for the contract may apply or may be standard. And those can be jumping off points for you as you negotiate or draft your contracts or have someone draft a contract for you. But again, it's just important to include that in the contract, say, how long is the contract supposed to last? And then at the end of that term, right? So if it's a 1-year term, 1-year contract, what happens at the end of that term? Does it automatically renew? Is the contract just over? What will happen at the end of that contract term? It's very important to include that as well, or at least think through it, right? Because if I don't include anything in it, in most cases, the contract is just going to end. All right. But if I don't say anything in it, that's also inviting some ambiguity about what was intended, and it gives space for a court to interpret a contract in a way that maybe you and the other party weren't necessarily, it wasn't necessarily the way that you saw it, or thought about it, or what you came to an agreement on when you originally signed the contract, right? And so this is something where it's important to be very clear, important to be very thorough about how long the contract's going to last and what happens after the contract naturally reaches its conclusion. Next are your key terms. All right. And so when I say key terms, I'm talking about things such as, the operative, what's the best way for me to put this? The operative language, or the operative terms in terms of what are the main obligations that everyone is committing to, right? And so, for example, to talk about a services contract, right? Like, let's say I run a cleaning business. I'm going to be cleaning commercial buildings, and I'm entering into contracts with the owners of these commercial buildings, or with the property managers of these commercial buildings. I'm going to lay out who are the parties to the agreement. I'm going to say how long the agreement lasts, but then I'm also going to say, here is what I'm agreeing to do as your cleaning company, right? I'm going to come every other week, or I'm going to come every week. I'm going to clean the bathrooms, the office space, and the lounge areas, right? I will bring a team of X amount of people. We will vacuum, we will, clean the floors, do a deep cleaning of the floors every 6 months, whatever those key terms are on your end. And then on the other side, there are going to be other obligations, right, that the property manager or the building owner is going to make to me, right? And so typically that's going to be paying me. But it's important to also lay out not just how much I'm going to be paid, but how frequently I'm going to be paid. What form is that payment need to be made in, and things of that nature. And so the key terms are really what the parts of the agreement that you've come to that really just outline what everybody is obligating themselves to, right? And so they're the terms that in every contract will change. In many contracts, there are some terms that, kind of stay the same. They're called boilerplate, but the key terms are the ones that change from party to party, from situation to situation. And they're the ones that you typically talked through and negotiated and said, these are the things that are most important, and they form the kind of core of our agreement. Next is risk allocation, right? And so this is something that is important to think about, and you might not always include terms in your contract that are really intended to kind of shift risk in a situation. That might not always be the case, but it is something that you should always think about and always discuss if it's something that's important to you, right? And so when I talk about risk allocation, one of the things that you can do with a contract is you can say who is going to be responsible or liable for certain risks, right? And so, for example, if I have a contract as a manufacturer to provide certain goods to someone, finished goods or finished products, we should say in the contract who is responsible for, damages in the event that all of the goods get damaged or lost in shipping, right? Like who bites the bullet in that situation? Is it split? Do you take it as the purchaser? Do you just, do I get to keep, what you paid? Do I give you a half refund? Do I refund all of your money? Do I take on all of the risk? That's just one example. And another really frequent example comes in with indemnity clauses, right? And so in a situation where typically a lot of times you're going to see these in service contracts, If I'm agreeing to provide a service for someone, they might want to include an indemnity clause that basically says I'm responsible for certain damages caused to third parties that are caused based on my own, negligence or my own actions. And they may include, terms that say that I'm supposed to defend, hold them harmless, indemnify them, so on and so forth. Basically, that's saying in the event that, through our contract and through the services that you're agreeing to provide, if a third person gets hurt or injured and brings a claim against us, you're agreeing to defend us in court. You're agreeing to, pay any of those damages that end up being owed, et cetera, so on and so forth. And so there are a lot of different ways to kind of balance out the risks in a contract. But the number one thing that you need to be aware of is that you need to think about, first of all, what those risks are. Typically, someone in the industry, someone who's a practicing professional, is going to have enough knowledge to be able to say, here are the risks that we need to be aware of and that we need to address. And then you want to make sure that those risks are properly addressed in the contract if necessary. All right. And then we have intellectual property. All right. And intellectual property, again, this is, similar to our risk allocation in that it might not always be something that's relevant to every contract, but in many contracts it is, right? And so intellectual property is basically something creative, something that's been created by someone that is not necessarily a tangible piece of property, right? And so it might be an idea or invention that's covered by patents. It might be a creative work of art, like a t-shirt design or a book or a piece of music that's covered by copyright. It might be a trade secret, like a customer list or a secret recipe, or it could be a trademark, like brand elements, like a logo, a slogan, a business name, right? And it's very important that you address if there are any issues or if any part of your agreement deals with the use of your intellectual property as a business owner. It's important that you outline how that intellectual property is going to be treated in relation to the obligations contained in the contract, right? And so typically the most frequent example of this is going to be in a situation where someone is agreeing to create something that might create some sort of intellectual property right? So for example, let's say I'm a graphic designer and someone has hired me to, create social media posts for them. Who is going to have ultimate ownership or the rights to own and control the artwork that's created for these social media posts, right? Who's going to own it? Who has rights to use it? Because those aren't necessarily one and the same. They can be different things. And so it's important to address that within the contract, right? Who has ownership over intellectual property? Who has the right to use it? Do both parties have the right to transfer their own rights to other people, right? And so, for example, when someone owns a piece of intellectual property, and they give someone else the right to use it, that's called a license, right? So they've now licensed that other person, given them a license to use that intellectual property. Well, is that license transferable? If someone has given me the right to use their intellectual property for a specific purpose, can I give that right to someone else, right? These are things that need to be addressed. Also, any situation where you're going to be part someone and they're going to be using your intellectual property or using your, a great example is, a trademark, right? If I hire a social media influencer and I say, I want you to, let's say I'm a clothing designer. I say, I want you to wear my brands in X amount of posts, per month. I also want to be very clear about what are the restrictions or what are the limitations on how they can wear and use my brand within the constructs of our contract and our agreement, right? And so I want to make sure that I'm protecting my brand in that situation by telling them you can't use our brand in these certain ways. All right. And so it's very important, if there's any sort of intellectual property being created or any sort of intellectual property, kind of being used between two parties, it's important to really, outline how those different situations are going to be handled, because sometimes people end up surprised when they don't address those sorts of things. They end up with surprising results at the end, particularly if there's a dispute that pops up. And so it's something that you want to make sure is addressed between the parties of the agreement. And then last but not least are your miscellaneous terms. All right. And so, like I said before, when I was talking about the key terms in an agreement or the essential terms in an agreement, your miscellaneous terms are also terms that are essential, but they're typically referred to as boilerplate, right? And so these are terms that address specific legal issues in relation to a contract that don't necessarily touch on what each party is agreeing to do on a practical kind of day-to-day basis when it comes to the agreement, right? And so, for example, some of the examples of that would be, how can the agreement be modified, right? Can the agreement only be modified in writing? Because if you don't specify that, an agreement can be modified verbally, right? And so if you and I have a written contract, and then, we're talking about the contract, and I say, you know what, I know we agreed to, that I would pay you on the 1st of every month, but I would really appreciate if I could pay you on the 13th of every month moving forward, because, that's when, whatever reason. If you agree to that verbally, we've just modified our contract, even though it's not in writing. So that's one of those things where if you only want the contract to be modifiable in writing, it's got to be there in the contract. It's got to be written in black and white. Same thing with, choosing how you're going to resolve certain disputes, right? So, parties can say in their contract, we're going to resolve this by going to mediation, or we're going to resolve this by going to arbitration, or we're going to, if we're going to resolve this, it has to be handled in a certain court, right? And so, for example, if I'm a business based in Philadelphia and I work with businesses around the country, something that might be important to me is to say, if you have a dispute, it has to be filed, we're agreeing that dispute has to be filed in the courts of Philadelphia County, Pennsylvania, right? That is something that, from a practical standpoint, is going to be very useful in the event that a dispute does arise, because it's going to then, hopefully allow me to ensure that, my costs aren't, through the roof, because now I've got to travel to, wherever else in order to be able to defend myself against a lawsuit. It doesn't necessarily mean that all the time that's going to be enforceable. It's going to depend on some of the other terms in the agreement, but including terms like that, can really be helpful in terms of just making sure that the agreement works out in a way that is towards your best interest, right? Other things such as what state's law is going to apply. Is it going to be Pennsylvania law? Is it going to be the law of, the other state of the person who you are working with? And then other things such as, notices, right? If I'm required to provide, 15 days notice in order to cancel or terminate the agreement, how does that notice have to be provided, right? Does it have to be in writing? Can it be verbal? If it has to be in writing, does it have to be sent through the mail? Can it be sent through email? Can it be sent through text, right? These are like the little things that need to be addressed. Other things such as severability, right? So if one part of the contract is found to be invalid by a court, will the rest of the contract hold up? Is the rest of the contract still valid? How is a court supposed to interpret that if part of the contract is invalidated? And so there are a lot of different things such as that, such as those that I've mentioned, that typically are considered boilerplate language that are included in most contracts, and really just address, some of those different legal issues that pop up, particularly when there's a dispute. How do we want to handle this? How do we want to make sure that this is address, what are the boundaries and limitations in terms of being able to address some of these different things. So some of the other potentially important terms that I just want to mention briefly, that you'll see sometimes in contracts, are definitions, right? And so again, as I mentioned multiple times before, in a legal sense, when we use terms in a legal sense, we might not always be referring to them in the sense that they're typically used in everyday usage, right? And so that's true when it comes to a statute or a regulation or a piece of legislation. It's also true when it comes to contracts, right? And so when I use a term within a contract, and I'm using it to refer to something specific, a lot of times it's a good idea to define exactly what that term means, right? And so, for example, if I put in my contract that intellectual property, or actually, here's a better example. If I put in my contract terms around confidentiality, it's important in that situation for me to define what confidential information is going to be under that agreement, right? So like, what is considered to be confidential information? How will both parties know that something is considered confidential, right? Is it, do we have to mark it as confidential? Is it, going to be in a certain folder in the Google Drive? Whatever the case may be. But it's a term that should be defined, because otherwise it leaves ambiguity, right? It comes back to the being clear, making sure that the contract is unambiguous. If I don't define that term, it's not going to be clear to the court, because they weren't there when we were negotiating. It's not going to be clear to the court what is supposed to be considered confidential information. And so, leaving that open-ended, not having a definition in a situation like that could lead to unintended consequences, right? And so definitions, defining certain terms is going to be important in your contracts. Recitals are something that you may see in contracts. Recitals are basically the terms at the beginning of a contract that say, whereas XYZ, whereas XYZ. Basically, what the recital is doing is it's laying out the facts that the parties understand or are in agreement to provide context to the contract, all right? And so recitals aren't typically considered binding terms in a contract. They're typically just considered to be, terms that add and provide context and allow a court or anyone who's interpreting the contract to kind of understand the mindset and intentions of the parties when they entered into the agreement. And recitals aren't always necessary in an agreement. Sometimes they're left out, depending on who's drafting them, depending on the situation. But recitals are something that can be useful, again, for providing context and making sure that someone who is looking at the contract, looking from the outside in, can really interpret and understand what's going on and where everyone's mindset was when they decided to enter into the agreement. Next, we have warranties and representations. These are basically terms in the contract where one party is going to make a certain, it's the right way for me to put this, is going to make a certain guarantee or a representation that either they are going to, that something is going to meet a particular standard. So that would be a warranty, right? So it's a guarantee that something is going to meet a particular standard. And if it doesn't, we're going to provide a remedy for that. A representation is basically saying that a certain fact exists and we stand on that. And if that fact does not exist, then we agree to be held legally liable, or we understand that we're going to be held liable for making that representation that was untrue or that was false. All right. And so warranties and representations are something that you typically will see in contracts, particularly longer ones. Remedies, sometimes contracts will state the specific remedies that are available to the parties in the event that the other party breaches or doesn't carry out their obligation under the contract. This isn't always the case, because when there's breach, legally, there are certain remedies that are going to be available to the non-breaching party, but sometimes it's useful to include specific remedies in order to, provide more clarity and a little bit more, foresight in terms of how something is likely to end up if it were to go to court, right? And so having that clarity, having a little bit more surety, provides parties with the ability to make decisions a little bit quicker because they know what's likely to happen. And so outlining the remedies in certain situations is something that allows the parties to do that. And then last but not least, confidentiality. If confidential information is going to be shared back and forth between the parties of a contract, this is something that typically is going to be included in that contract, or at least should be included in that contract, to make sure that that confidential information is protected. And it's one of those situations, confidentiality wise, one of those situations where you often will see terms that lay out specific remedies that are going to be available, because a lot of times, typically the remedies that are going to be available for breach of a contract are going to be money damages, right? And so if someone breaches the contract and I sue them, I'm going to receive some sort of compensation, some amount of compensation to kind of set things right. When your confidential information has been shared by another party, financial damages or receiving compensation isn't necessarily going to put you in the same place that you were in before, right? And so certain things like getting an injunction or specific performance, which is basically a court telling another party, you have to do X in order to make this right, whether it's, you have to stop sharing this information, or you cannot post this information on your website, whatever that might be. The court is telling someone you have to do something specific rather than saying you have to provide compensation, right? And so that's one of those situations where, with confidentiality, where you typically will see clauses or terms that lay out what the specific remedies need to be in order to make things right. So we've reached pretty much the end of our workshop, and I just want to do a quick recap of what we covered, right? So we talked about what a contract is, right? The fact that a contract is an agreement between two parties that's legally enforceable, and that all contracts are agreements, but not all agreements are contracts. The difference really comes in with the contract being legally enforceable and having those 6 terms met, an offer, an acceptance, consideration, mutual assent, capacity, and legality. All right. And having those 6 things present will typically mean that a contract has been formed and that it's legally enforceable. All right. We also talked about why contracts are important, right? And contracts are important because not only do they give you something, if you go into court, helps you avoid a he said, she said situation, because you have, very clear terms. It's clear to the court. It gives them something to interpret in terms of being able to determine whether or not a party has met their obligations under the contract. But really, a contract is meant to keep you out of court, right? And so it should be drafted in a way that is most likely to lead to success in terms of the business relationship between the two parties, right? And so we talked about what goes into a good contract, the qualities that should be in a contract to help to build that successful business relationship, right? We talked about fairness, we talked about clearness, and writing a contract in plain English. Excuse me. Writing a contract in plain English so that the parties can understand it. We talked about a contract being unambiguous. We talked about a contract being complete, right? These qualities that are important to include in a contract, or important for a contract to have, in order to have the highest likelihood that the parties will find success in their business relationship. And then we talked, last but not least, about the essential contract terms, the terms that are typically going to be included in a contract or should be included in a contract, to make sure that it's covering and protecting you, and really just make sure that you're able to take advantage of this, whatever new business opportunity it is, but you're not putting yourself in a situation where you're exposing yourself to too much risk. All right. And so, like I said, that brings us to the end of the workshop pretty much. And I want to ask are there any questions before I sort of wrap us up and bring us, take us to the outro? All right. Let's see what we have in the chat. My mouse is not working. There we go. All right. Any questions? You can put them in the chat. And if you do have a question, feel free to throw it in the chat. I'll go ahead and answer it. But again, since we're now at the end of the workshop, I want to, just say, give you this one piece to remember and take with you. And it's just that the purpose behind a contract. And I think it's always really important as an attorney, and as an attorney, really, I'm a professional problem solver. That's the way that I think about what I do. And as a problem solver, you always want to think about how you design a solution for a problem or create a solution for a problem. You always want to do that with your overall goal and purpose in mind. And so I want to leave you with really just reminding you that the true purpose of a contract is to keep you out of court, right? And so it's important to draft a contract, again, in a way that's going to allow you to be successful, and that is, going to allow you to be able to use that contract as a guide to really kind of move you through your business relationship and ensure that everybody is getting some sort of benefit out of it, because that's going to be the way that you create long-lasting, beneficial business relationships. All right. And so if the contract, isn't spelling out a solution, it should at least provide a jumping off point, so that, ultimately you're able to stay out of court, because that is, that is failure in terms of, for a business, ending up in court can spell failure, particularly for small businesses. I know large businesses have the, budget to pay for lawyers and do that sort of thing. But as small business owners, that's not really where we're at. And so we need to avoid court if at all possible, except in a situation where we just really need to enforce something in order to make sure that we get something that our business needs, right? And so that is, I just want to leave you with that in terms of reminding you and helping you remember what the true purpose of a contract is. It's not to, impress someone. It's not to, not necessarily just for a court to have something to interpret, but the real purpose is to make sure that we're creating a guideline and an outline for a business relationship that's going to be successful. So question, can invoices be a part of a contract? The answer to that is yes. Anything can be part of a contract, which is part of the reason why it's important to be complete, unambiguous, and clear and concise when drafting a contract. Because depending on what the invoice says in it, it can be interpreted as changing contract terms or changing or altering what's in a contract, right? So again, as I mentioned, one of the key terms that is often included as one of those miscellaneous terms in a written contract is going to be pertaining to modification of the contract, and how and under what circumstances can a contract be modified. And if you don't say anything about how a contract can be modified, something like an invoice can end up changing the terms of that agreement if it includes something in it that says, for example, if the invoice includes something in it that says, hey, I know that I was supposed to pay you $500 this month, but I'm just going to pay you $250 and give you the other $250, next month. That can alter the terms of the agreement by creating a implied agreement between the two parties, especially if that statement is put out there and then it's accepted by the other party, like, okay, I'm fine with that. That can change the actual terms of the agreement. And so it's important in your contract, if you don't want your invoices to be something that can alter the contract, or if there are other things, other situations, circumstances where you don't want the contract to be able to be modified, it's important to put that in the contract and spell that out. But if you want your invoices to be part of the contract, again, It goes back to completeness. If that's something that you want in your contract, that's something that you should put in there, that the invoices are considered a part of the agreement, and that the terms included in the invoice will also be included and considered part of the contract. So good question. If you have any other questions, feel free to throw them in the chat, of course. But last but not least, in terms of what's next, I will be developing a workshop on contract negotiation, right? So we've talked about what goes into a contract. I want to also do a workshop that kind of covers negotiation and helps you kind of think through, you know, how do I use my position, or how do I use leverage? You know, how do I think about negotiating a contract to make sure that I get everything out of it that I need, and make sure that I'm putting myself in the best position possible, you know, for future success. And so stay tuned for that. I would definitely encourage, if you're not already, and I'm going to throw in the chat a link where you can subscribe to our email list, just so you can stay up to date on you know, events and other workshops that we'll be holding, whether in person or virtual, and you can just keep up to date with all of that. But stay on the lookout, like I said, stay on the lookout for that workshop coming up. And last but not least, again, you know, number one, I want to thank you for coming out this morning. If you have any questions or anything that you'd like to follow up on, I'm always able to be reached. You know, you can definitely check out on the internet, check out our website, all of the information in terms of being able to get in contact with me, set up a consultation. Our phone number is right there on the website, which I'm throwing in the chat as well. You know, but like I said, I'm here to empower entrepreneurs, and you know, my goal is to help everyday people do extraordinary things. And so I want to help people own their future, and really just use the skills and knowledge that I have as a professional problem solver to help folks be able to realize their dreams and business goals. So I'm here if you need me. But that brings us to the end of today's workshop. And again, I appreciate you coming out. And if you have any questions, let me know. But otherwise, enjoy the rest of your weekend. I hope it's relaxing, and I hope that you find a good way to beat the heat. All right, so take care, and stay safe.